Morning, everybody, and welcome to the latest in the My BPF Digi series of webinars. This morning, we're going to be talking about something that is sadly very topical, and that is CVAs. Landlord CVA, is it here to stay? I'm joined by a stellar panel of experts to talk about this, both from a practitioner point of view and from a very real experience point of view of CVAs. So I'd like to welcome everybody for joining us. Please do use the Q&A function as we go along to raise questions of our panellists. This is meant to be an interactive session. We don't want to do all of the talking. We want to hear from you. So post your questions and comments on the Q&A function, and I will pick up as many of your questions as I can as we go through with our panellists. So without further ado, let me turn to my panellists. I have with me, I'll do them in the order I can see them on the screen, which may not be the same as you, Stuart Perry, who's chair of R3's General Technical Committee and a partner at Freshfields, specialising in...
Field Fisher rather than Freshfields. I get a pay rise.
Field Fisher.
Freshfields. That's fine.
Apologies. That's not a great start, is it? I'll try and do better from going on. Matthew Ditchburn, I think I can assert with confidence, is head of real estate disputes at Hogan Lovells. Christina Beggan, an asset manager at Alandi, and Ian Burton, founder, I believe, of Aspinalls of London. So very personal experiences from him, I'm sure we're going to hear. I'm going to ask each of them in turn just to set the scene for us from their perspective. And then, as I say, we'll start a conversation and open up some of the issues that they raised. So Stuart, I might come to you first, if I may.
Wonderful. So I'm an insolvency guy rather than a property guy. So my world is insolvency practitioners and insolvency law. And I think CVAs are a good thing. And I am hopeful that we will see more of them in the coming months as we battle through the COVID pandemic and what it means for people. I can elaborate on that a little later. We'll get into that some more, I think. Christina?
Yeah, I currently manage a number of retail assets across the UK and have assisted a number of our investors through the CVA process as we see more and more of them. I don't necessarily think CVAs are a bad thing, which may sound strange coming from a landlord, where they are used properly and as intended and managed properly. It's this sort of thing that they've morphed into more recently, whereby certain unsecured creditors, such as landlords, are disproportionately affected. I think that's where that's where a lot of the discontent and the frustration has come from.
Thank you. Ian?
Well, look, CVAs for someone like myself, who's a founder and a brand owner and has a brand that's still privately owned, so we're not private equity backed. It's an absolute last resort. So I think it's a very good thing that there is a last resort, last chance, potential way of salvaging, your life's work, for example. But I have found it, and my team have found it, confusing on many levels. And I'm sure there are things that could be done to make the process more transparent, more cooperative with landlords particularly, and less confusing.
Thank you. And Matthew, lastly to you.
I'm Matthew Ditchburn. I'm head of real estate disputes at Hogan Lovells law firm. I act for both sides of the divide. So I am both a landlord man and a company man, if that's the right way to describe it, although probably at the moment, mainly landlord side advice. I'm also the vice chair of the insolvency committee of the BPF and have been for a long time. I do not think that CVAs are an inherently bad thing. I think that CVAs are a valuable restructuring tool that can be used to rescue a struggling business. But at the same time, I can well understand why they have become very controversial, both because there is a sense amongst some that some CVAs go way above and beyond what is needed to address the immediate problems of the business, and also because of the wider sense that whereas in the quote-unquote olden days, the shareholders or the the bank behind a struggling business might be the ones to bail it out. Under a CVA, it seems that it's now the creditors who have the responsibility for bailing out a struggling business. And of course, they get no upside because they don't own any equity.
Thank you very much. Well, that's good because we've managed to reach one point of agreement already, I think, which is that CVAs are potentially and should be used as a valuable tool for businesses in distress as a mechanism to try and navigate a way through that with the support of their creditors. So I think we'll bank that, but I think we're also then moving on to acknowledge that, at least from landlords' perspective, there are problems with the way CVAs are now being used, and that I think it's fair to say there's some doubt over whether or not in all cases they're being used in the way that the legislation intended. So let's just talk about that a little bit more. Why do we think, Stuart and Matthew, I might come to you first on this, why do we think we have seen such an uptick? We've seen, I think, at least 17 large retail CVAs this year already, and I'd be astonished if we don't see more before the end of the year. Why have CVAs come back on the agenda with such vigour during the year? Is that just about COVID, or is there something else going on as well? Stuart?
I think a lot must be said for the economic position that retailers find themselves in. Obviously, there's just no footfall. So their ability to pay rent is what has just fallen through the floor. And whilst it is possible for them to manage other overheads, they're not turning the lights on, so their utility bills aren't as great. They're furloughing all the employees, so the government's paying for it. And if not, I'm sure we're going to see loads of redundancies for retail staff, which is another very sad part of the COVID crisis. So then the only really other large overhead that they've got that they cannot control is the amount of rent they have to pay. And I think that obviously the companies that are in that position need to try and deal with that rent burden somehow. And it's difficult for them to foresee a way to trade very profitably in the near term because lockdown's still here and it looks like it's coming back. So there aren't that many options of dealing with it. So you've either got bilateral agreement with your landlord, which is great if there aren't that many and everyone's on the same page, they can consensually do it. You go into an insolvency process that is a terminal, a rescue one, hopefully like an admin, or a terminal one like a liquidation, or you propose a VA. And I think, as we've heard people say, a VA is a good way of rescuing a company, provided it's used properly. So I think we will see an increase in CVAs because there will be debts that need to be dealt with, and people need to react to what the new normal is. I suppose the question then becomes, what should those terms be and how should it look? And I'm sure Matthew will have some comments on that from the ones that he's seen recently.
Matthew?
So what is going on, and is it more of the same? So we had a kind of wave of CVAs which started, I think, probably 2017, 18, mainly retailers, and that was a result of various things. It was Brexit, it was business rates, and it was also the kind of move to online. And lots of retailers realized that they didn't need as many physical stores, or the physical stores that they had were too big, and they used CVAs as a way of addressing that issue. At the same time, we saw quite a significant correction in the sort of casual dining sector, where a lot of people who had expanded quite quickly in quite expensive locations in the previous sort of 5 to 10 years realized that they didn't need that much space. So that is why we had a big wave of CVAs sort of 2018, 19. That kind of came to an end at the end of last year. At least it got a lot quieter, and there were various reasons for that. We had the Debenhams case, and also there were a lot of CVA challenges being brought to courts, and people might not be aware of it, but a lot of CVAs are challenged at court. And I think it became a very, very choppy marketplace for people to be introducing CVAs into, and it was viewed less like the soft option that perhaps it had been seen as before. And so Q4 last year, Q1 this year, not very much CVA activity, But of course, now we've seen a massive boom in CVA activity post-COVID. And there is something slightly different going on. It is not just retailers saying, well, we've got too much space because a lot of our market's gone online. It's retailers as addressing the significant trading problems that they've had around COVID, not being able to trade for 3-4 months, and then obviously the recovery period after that. So it's retailers, and obviously hospitality has suffered very badly because they don't have the online sales to back them up. That is kind of all fair enough, you might think, but the controversy that I think we're seeing is that some people see CVAs, COVID CVAs, being used rather opportunistically to go further than is necessary to deal with the COVID issue. So you might say that the typical COVID CVA should just be a rent deferral where the company gets a bit longer to pay the rent that it couldn't pay during March, April, May, June, or maybe a reduction in rent to reflect the fact that it couldn't trade. And that might not be that controversial in itself, but instead what we're seeing is CVAs which reduce rents for 2-3+ years based on insufficient transparency. I think landlords would say, we're not seeing the forecast to back up and justify why we need rent reductions for such a long period. And then at the end of that 2 or 3 year period, typically we're now seeing an upward downward rent review being built into the end of the rent concession period. And again, that's a point of controversy that landlords they don't like, and they don't understand why it's necessary. They take the view that, in 2 or 3 years' time, either the CVA has worked and you are now back on a stable footing, or it hasn't worked and you're an admin. But either way, you don't need an upwards downward rent review in 3 years' time. And it is that sense that CVAs are being used opportunistically, if that's the right word, to rebase rents because retailers think that they are paying too much rent and they want to take the opportunity to change that, whether or not the individual stores are profitable, whether or not they are struggling financially. So the COVID model of CVA seems to have expanded beyond what is needed for COVID, I think, is the sense that some people have.
Thank you. Ian, I'm going to come back to you in a minute and ask you a little bit more about, your motivations, your experience, and pick up that transparency point from a retailer tenant perspective rather than a landlord perspective. But before I do that, Christina, just your experience in terms of what Stuart and Matthew have been describing in terms of, if you like, the way CVAs may have changed and the way they're being used being changed over the last few months. Is that reflected in your experience?
Yeah, that's exactly, I think, the concerns that we've seen. Using a CVA to restructure a genuinely sort of struggling business is the spirit of the CVA is not the issue. What we've kind of seen is sort of them being used more and more disproportionately affecting landlords as unsecured creditors, and also I think an unclear logic as to how certain stores are categorized, and therefore some stores it almost seems cherry picked, and it's sort of potentially used as a tool to kind of shed stores that aren't performing for that retailer, and it's a real lack of transparency between the landlords and the occupiers as to how that methodology is formed, and how you end up with a store in a specific category.
Yeah, I mean, just you would look at a typical, just to agree with that. I mean, you'd look at a typical CVA proposal that we've seen post-COVID, and you might discover that 80 or 85% of the stores are so-called Cat B or Cat C stores, which means it's a rent reduction or a closure. The implications that all of those stores are loss-making, but there's no data to back up the suggestion that all of those stores are loss-making. And landlords think, well, they can't all be loss-making because before the COVID pandemic, this company was making tens or even hundreds of millions of pounds of profits. So how can they now say that 85% of their stores are loss-making?
Thank you. Ian, you rightly reminded us, I think, before we started and when in your first interventions, that we do tend to talk about larger retailers, larger landlords when we're talking about CVAs, and those are the ones that tend to hit headlines and be really controversial and really quite acrimonious at times. But this is a story with many facets. There are small landlords, there are small retailers, also trying to navigate this hugely complex environment. So would you mind sharing just with us a little bit more of your personal experience of this? And you talked about transparency up front too, from your perspective. We're hearing it from the landlord side. So just would you share with us a little bit more of your experience and how you came to think that CVAs were the tool you needed to use and why that was and what your experience is of it?
Yes, of course, Melanie, but can I just go back a minute? And, my panelists have been very articulate and very eloquent talking about, the sophisticated, CVAs are perhaps being used not as they were intended to be used. Now, I am an entrepreneur, have been building Aspinall for 16, 17 years. We only have 10 stores, as I said at the beginning. So my experience is on a very small level. But as a tenant of 10 or so stores in London, struggling over the last few years, that's the perspective I can give. But look, surely we've got to go back a step. We all know that COVID has devastated retail worldwide. Okay, so we know that. Okay, but before that, as Matthew said, in years 17 and 18, I think it was, Aspinall and our own 8 to 10 stores, we had £1 million of occupancy cost increases, right? In 2 years of rent increases and rates increases. Now, the landlords are not to blame for the rates increases. And if I was in government, I'm trying to work out why would your government put rates up like that? They're probably thinking, well, the landlords are enjoying these rent increases every year or every time there's a break every 3 years. We'll have some of that. We'll slap on the rates so the landlords can't have those increases. But actually, that didn't happen. The increases went up, the rates went up, and everybody, I think Matthew mentioned in 17, 18, it's just tipped the balance from a economically viable store to just being completely unviable. Okay, we were just hanging on to our stores, with fingernails, making a little bit of EBITDA, just about making them profitable before COVID. Okay, and how is it possible, as my head of retail says, that we're making over £1 million revenue in X store, Y store, Z store? I won't mention any particular stores right now, but we can't make a profit. How can that be possible? Something is radically wrong before COVID. Okay, has to be wrong. If Aspinall can't do 1.2 million revenue, 1.3, 1.4, 1.5 revenue in a store and still not making any profit, and it's not because of our gross margin, there's a problem. Okay, I absolutely think, and I'm sorry if this sounds contentious, and I'm not an expert, as I say again, but I think there has to be a radical readjustment of the retail high street. And I think there's a lot to be learned from China, right? China, it's not landlord-tenant, if you know what I mean. It's landlord-partner. Everybody's on turnover rents, okay? Your landlords are your business partners. It's not a tenancy arrangement. And that's why the landlords will select the brand that goes in there. They give them a 3-year lease. If you don't work, you're out. But you can't just pay rent to stay there, okay? It's a turnover model, and it absolutely binds the landlord and the brand to a partnership. You win, I win. You lose, we lose, okay? And, look, this is just, it goes way deeper than this. This goes back to, landlord law from hundreds of years ago, upwards only, rent increases, and all of those things. I'm sorry to say, forgive me for being contentious, but it's madness, okay? It's just so out of date. You can't survive on it. So I don't want to make go on and make a mega speech on it, but it's what I'm saying isn't rocket science. It's very simple, common sense, and everybody knows it. Okay. Now, whether there are big retailers or whoever they are taking advantage of the situation, I don't know. Matthew, I would just say, referring to ex-retailer who was making 100 million profit before, and how can they not be making profit now? I would just turn that back on its head and go, well, if their store was profitable and your projections on a 3 to 5 year model looked reasonably safe and secure, why would you close your store? You wouldn't. So they're closing it or doing that CVA for a reason. They just are too scared about the lease increases, too scared about the upwards only rent increases, and I imagine that they have to basically run for the hills. So, we are in a cataclysmic, fundamental paradigm shift. Everybody knows it, okay? And there's no point trimming around the edges, asking if this is right or wrong. COVID's flattened everything. I don't want to be too brutal, but we all know it. The next panel, Melanie, should be, how do we get life back into the high street? What have we got to do? And the government's done some fantastic things with furlough and cutting rates, all of those things. And it's going to be a very interesting conversation of what we do. But as a small retailer with an owner of a comparatively small business and brand, all I can say is the only way forward has to be turnover rents, and then then you're partners with the brand, and that's the way forward.
Thank you. If that wasn't an impassioned speech, then I'd hate to see you giving an impassioned one.
That's me on a dialed down zone.
I think you've said so much there, Ian, which I
can go on another half an hour, but I'm sure you will.
Well, I think, but you're right. There are at least 2 other panels in what you've said, and we may be able to come back to the issue of the future of leasing structures, either at the end of this one if we run out of questions on CVAs, or in a future panel. But this is supposed to be a panel about CVAs, so I'm going to drag you briefly back to your CVA before I ask Christina to respond to some of that, what she's heard. And so what are you hoping the outcome of the CVA process is going to be for you? Where do you want to get to?
Oh my God. Well, obviously, Melanie and everybody, for us, I'm praying that we will get the votes and the supports from our landlords so that we can salvage the business, which underneath it has a beating heart of a very successful brand and a very successful business, and restart. Of course, I'm not just hoping, me and my team are praying for that. In my experience, we're in the middle of it. Melanie, I don't want to take, there are a number of things I think I could suggest that may improve and help CVA processes, but perhaps we can come on to that when you're,
Let's do that. Thank you. Christina, your tenants, I imagine, come in all shapes and sizes, and there'll be stories like Ian's, but we do have this issue, I think, which you've already touched on, of, particularly, I think, private equity backers who have a particular business model which makes the assets vulnerable and therefore helps them in the CVA process to argue a position which feels quite unfair from a landlord perspective. But just give me your take on some of the things that Ian said and some of the things we've talked about so far.
Yeah, I mean, I absolutely sympathise with Ian's a lot of the points that Ian raised. He's talking about sort of super prime London market where rents are incredibly expensive. There is quite a lot of demand for those stores, and it's not unheard of that there's quite hefty rent increases in those kind of super prime London locations. So that definitely gives us a good insight into that sphere. I don't necessarily think that that's the case across the whole of the UK. Certainly not on many of the assets that I work on, sort of range from sort of Kent to the Midlands. A huge issue that we do come across is the business rates. In some cases, the business rates are higher than the rents that we have on some of our stores. And there's no way of, we go through the appeals process, we assist tenants in whatever way we can to also put forward appeals, but there's no way of reducing that cost materially. At the moment, we've obviously been lobbying for the government to change that, and we'll hope that they will do so. But for the moment, we're stuck with what we've got. And, there are a lot of costs in occupying a store, but it's not just the rent, but the rent plays a big factor. We have had a lot of conversations recently because of COVID, and some were prior to COVID, of direct dialogue with occupiers as to how can we reduce rents or work with them, which is positive to try and have that conversation. It is sort of, I think, difficult when you have some of the bigger retailers or that are sort of heavily advised by practitioners, and you end up with rent cuts, and it's just really unclear as to how those have been applied, and is it based on affordability? Is it based on that store? What is the turnover of the store versus the cost of the store? As Ian was saying, in his case, it really didn't leave a lot left over for him to be able to grow the business. Which is not what we want. We want to grow the business. We want tenants to remain in place. We don't want empty shops. We don't want people to lose jobs. So it's in all of our interests to try and work together on that. But I completely appreciate what Ian's saying about his circumstances. I think that's obviously very, very difficult.
So do you agree with that sort of concept that Ian was talking about of it's a partnership, it's an economic partnership between the landlord and the tenant? Because something that's coming through on the chat function is, that one of the challenges in this may be both from a private equity-backed tenant or from a landlord perspective, is that kind of lack of engagement, whether it's the passion of Ian building a business in retail, or whether it's the commitment to place and community that a lot of landlords have. If that passion on either side isn't there, then you don't get that sense of economic partnership. But I guess for a landy, you very much have that partnership model. Yeah,
and we do. I mean, and turnover rents, as sort of Ian discussed, traditionally a lot of private equity funds and things haven't been what they want to do. Haven't necessarily, it's just not something that everyone was comfortable with. I think we're seeing that more and more. It's definitely a lot more widely used, and you can see the benefits of it in terms of if as Ian says, if you do well, we do well, and it's sort of sharing the pain. I don't think I think there needs to be an overhaul, I guess, in how we look at those turnover rents. But I don't, they're not the enemy as they have sort of been in the past, and it's definitely something that we aren't averse to, and that all feeds back to this transparency and communication. If I think traditionally it's been very difficult to agree turnover rents and agree rent concessions and agree whatever, because we just have not a huge amount of oversight over how specific stores are doing, or how retailers are doing, and there's just not, the dialogue does need to be improved, I think, on both sides.
Okay, so let's come back to my two practitioners then, and ask both of you, how is this working, and is it getting more difficult? Whether that's about Zoom meetings rather than physical meetings, or whatever else the factor is. I mean, are they becoming less transparent, more difficult? Whichever side of the fence you sit on whatever role you're playing, do you see that as a challenge that is also getting in the way of getting to whatever people think the right outcome is? Stuart?
I was going to say something now, actually, in support of landlords. I think there has been a lot of protection given to tenants by the government in the COVID pandemic, and I think there will come a time when someone then needs to say, well, what protection is being given to landlords? Because obviously landlords have borrowed money to buy property as well. They will have a commitment to pay X amount to their bank at X time. And if they're not getting any money in, then obviously that will mean they can't comply with their own obligations as well. So we might see landlord CVAs that are nothing to do with tenant landlord. It's landlord financiers from their side. And I think that this kind of parts comes to what we've seen with some of the comments about the financialisation of the high street, and you've both got tenants working on small margins in retail, which is very difficult anyway, and then you've got landlords that are professional landlords that are geared themselves in a certain way and need a certain level of a guaranteed income, like pension schemes is the obvious one, where they've got annuities to pay and things, and then when you've got those two conflicting, it's very difficult to build a compromise when you've got two people that need something. So it's not until you've really moved the mindset to a situation where it is more of a partnership, as Ian was saying and Christina was saying, that you can kind of get the fluidity to allow that. But that's that bit of it. I'm a proponent of CVAs. I'll come on to that a bit later. And I think one of the issues you're saying is, how does this work practically in a minute? And I think that a lot of the issues that we've got here is really just focus on the larger VAs. If you look at the smaller ones, where it's a small number of locations and it's a small scheme, it's not that complicated. There aren't that many categories. It's a lot easier for everyone to understand what's going on. And I think a lot of the complaints about this appear to be the very large retail schemes, and how should we run a meeting and how should that work? And I know there are some criticisms of that. A question that was asked of me historically was, how should virtual meetings compare to physical meetings? So I will answer that one now before someone challenges me with it. On the basis, I think they should be the same. There shouldn't really be a difference, but it's a lot more difficult to chair a virtual meeting than there's a physical one, as I'm sure Melanie can attest. You can't see the reaction of people, find out who's really wanting to say something, or someone just got a list of questions they want to cross off. And you need to manage it in a way that actually allows the meeting to conclude in a sensible time. Because if the vote is at the end, you don't want 10 hours of questions, by which time most people have got bored and left. It needs to be effectively managed. And I think as well as navigating the difficult situation we find ourselves in with the COVID pandemic, economically, we've then got the technological difficulties as well. As for instance, I'm talking to you now and concentrating on that, and I'm not seeing all the questions that are coming up or the chat function to be able to respond to it. So I don't know if people are saying Stuart's speaking rubbish. So it is difficult to technologically manage this. So I think there is a lot of learning to be done from both sides as to how it can operate better, and also provide the right amount of information to allow it to progress smoothly and everyone understand where they are.
Thank you. Don't rest assured, Stuart. I will tell you if anyone comes up on the chat line and tells you you're talking rubbish. I will let you know, I promise.
Thank you.
Matthew, over to you for some thoughts on the process. And there's quite a lot of energy on the chat function and the Q&A function around this issue of picking up on the comments of partnership, not so much disagreeing with them, but I think expressing the view that partnerships have to be based on trust, and that trust is in short supply in some of these conversations and some of these relationships. And Ian is waving at me, so I'll let him come in before I come to you, Matthew, but I am coming to you next. Ian.
Important point that I wanted to make. So we've had long relationships with all of our landlords, most of them in central London, and we've had great relationships, not on a very personal level, but, at least on a collegiate manner. And, our landlords have been very supportive of us in many ways. When we started on this CVA process, I wanted to go and talk to our landlords and just tell them what was happening and at least keep them informed. But we were advised, and we've got 2 lawyers on the panel, we were advised absolutely you must not go and talk to the landlords at this time. And, once we've launched the CVA, then you go and talk to them. So that was one of the most confusing messages and completely against my own personal way of doing things. And I actually think 2 lawyers here, if you're going to do a CVA, there should be an obligation on behalf of the retailer to inform the landlords as soon as it's being planned, and an obligation for the landlord and the retailer to engage in a discussion. That makes sense to me. Like, is there a last chance of resolving something? If not, we have no other choice but to do the following. But that's not what we were advised. So I think, if we're talking about what comments, what could be done better, I think that's a very important change that should be considered.
Thank you. Matthew, do you want to pick that up very directly, as well as all the other things that I've sort of thrown at you?
Got a very long list of things now.
Yeah, absolutely. Go for it.
Okay, well, let me deal with that last point first, which is about prior engagement. I think the reason that Ian's lawyers advised him not to engage with landlords pre-launch of CVA was because of the risk that all of those landlords would then get wind of the fact that there was a process coming, and they'd all start enforcing in whatever ways were available to them to try and beat the pack. That, I think, is understandable, but probably unfortunate. So there are 2 things which a retailer could do in that scenario. The first one is the BPF does and has for a long time offered a confidential prior engagement process, and I would encourage all retailers and others that are considering CVAs to use that. So you can speak to the BPF's insolvency committee, which is populated by mainly institutional landlords and other landlords, and they will sign an NDA, and it doesn't leak out to the market, and they will give you a perspective on how landlords may or may not view what is being proposed. And that has resulted, in my experience, in some very, very positive changes being made to CVA proposals, things which the company can accept, can live with, but things that will make the CVA more palatable for landlords. It's not crossing any red lines, and frankly improves the chances of it being supported. So that is one thing I would encourage. The other thing that we all need to remember is, as a result of the Corporate Insolvency and Governance Act, which came out this year in light of the COVID pandemic, there is now a new moratorium process available to all companies who are considering a restructuring process, including a CVA. So if you are considering a CVA, you can get the benefit of this moratorium, which stops creditor action for a period of time whilst you then engage. The whole point of that legislative change was to encourage pre-CVA engagement and to give for doing it. The reason I think that it's not being used is because the legislation requires the company to pay as you go. So any debts that fall due, including rent, during that moratorium, you have to pay. And sadly, one of the consistent themes that we're seeing with COVID CVAs is they are writing off all of the rent arrears that have accrued during the CVA period. So all of the companies that are not yet doing CVAs, and they might be waiting until 2021 when all of the current protections expire, they will then get the benefit of writing off 3/4 of 2020 rents. So that's 2 points about engagement that I wanted to make. I'm trying to talk quickly, so hopefully I'll get through this all in a limited space of time. I just wanted to respond to Ian's comments on the landlord and tenant relationship, which was quite an impassioned plea, and I think had an awful lot of sense in it. And I'm sorry not to be setting up a Biden versus Trump clash, but I do actually agree with the principle of an awful lot of what Ian was saying. Maybe there does need to be a change in the way that the relationship is looked at. Maybe it should be more of a partnership. Maybe there should be more turnover rents. Maybe landlords should more aggressively manage their retailers, shorter leases, landlord breaks if they don't reach a certain level of turnover. That is a model which I understand has been applied quite successfully in outlet malls, for example, where it's much more aggressively managed. And maybe all of that has to happen. And maybe one of the words that is always used in conjunction with COVID is acceleration. Maybe that change is going to be accelerated by COVID, and there will be a rebasing. All of that is the future, and it might happen. The one thing that I would say is that a CVA is not the mechanism and should not be the mechanism to enforce that change. A CVA is an insolvency process which a company can use to do what is necessary and only what is necessary to avoid a more formal insolvency process. The CVA, I think most landlords would say, is not a mechanism to force a change in the market because you don't like the way that it works commercially. That has to be done through engagement with landlords. A CVA is not, we talked about an economic partnership. A CVA is not, by definition, not an economic partnership. The way that a CVA works is that the landlords who are, upon whom these rent reductions are being imposed, are being crammed down by other creditors, whether they like it or not. So a CVA works because 75% of creditors by value support it, and all creditors get to vote on it, not just the landlords. And the reason that it's controversial is because typically the creditors who are not being impaired get to outvote the landlords who are being impaired. And mathematically, the way that landlords' votes are calculated, in the vast majority of these CVAs, even if all of the impaired landlords voted against it, the CVA would still be approved. And that, in a nutshell, is why they are controversial. It is not an economic partnership. It is a change that is being forced upon landlords against their will. And that is why they're controversial. And just to come back to Stuart's point about the way that creditors' meetings are being conducted, and I do understand all of the technological issues around COVID and having to have creditors' meetings remotely, but I would actually object to the opposition to a creditor, be that a landlord or anybody else, attending a meeting and having a list of questions that they want to cross off, or even a meeting lasting 10 hours with lots of questions. I'm sorry, but some of these creditors are losing millions and millions of pounds of value. And this is their one opportunity to ask questions, their one opportunity to try to understand what is going on before they make their decision. Frankly, I think if you've got a list of questions, you should be allowed to ask them. If it takes 10 hours, it takes 10 hours. It might be affecting the next 3 or 5 or more years of your relationship with that company. I don't think, and I have heard this from a number of BPF members, I don't think it is right to use remote creditors' hearings as a way of suppressing that debate. You should not be filtering difficult questions from landlords that they want to pose at creditors' meetings. The transparency is what is needed to make to improve the trust in the process. And from what I've heard about creditors' meetings where questions are being put in a chat room and are being filtered by the chair so that, frankly, they're answering the easy questions and dodging the difficult ones. That doesn't help. And I think they should just let people ask the questions that they want to ask, even if they are difficult questions.
Some support coming in on the chat line for you on that point, Matthew, with one participant expressing frustration that a number of questions that he asked were just ignored and moderated out. Although in another example, one creditor was given 45 minutes in which to ask questions. So I think good and less good experiences.
It's a balance, isn't it?
It is a balance. Do you want to comment on that? There's a couple of other things for Matthew, but do you want to comment on this point as well before I come back to him?
Yeah, and I don't disagree with a lot of what Matthew was saying either. And I think it's finding the fair balance, because if one creditor is asking the same question 10 times but in 10 different ways, you would expect a good chair to tell them, you've had your question now, we need to move on to other people. And if someone's asking irrelevant questions, you would expect the good chair to say, that's an irrelevant question. And an effective chair would do that. And to the extent it needed to last 10 hours, okay. But I've not seen one that needed to last 10 hours. And I've not seen a creditors meeting in a formal insolvency situation where they've lost everything. Not that, we don't know quite how the future relationship's going to go. Everything's gone and people have lost millions. I've never seen that last 10 hours. So there is a limit, and there is a balance to be made between what's an effective meeting and what's not. But that doesn't in any way downplay the fact that people should have an opportunity to ask questions. And I don't think virtual meetings should be used by people to hide from questions. But
I think that's right. I mean, it should be exactly the same approach as you would have in a physical meeting. I agree that if people are asking irrelevant questions, then the chair has to manage that. If people are asking the same question over and over and over again, then the chair has to manage that. But aside from that, if people have lots of questions, they should be allowed to ask them. And, I've also, for the avoidance of doubt, have never been to a 10-hour creditors meeting, but I did go to the Debenhams creditors meeting, and I did go to the House of Fraser creditors meetings. And those big ones, well, they might not be 10 hours, but they're probably 4 or 5 hours. And it's 4 or 5 hours, in my recollection, of genuinely important questions. People want to understand what is going on. Questions like, is my store profitable? Why are you reducing the rent on my store? And everything that Ian said about changing the landlord and tenant relationship sort of feeds into that lack of understanding of what is going on. If you read a CVA proposal now, it doesn't say Cat B stores are all loss making, so we have to reduce the rents. It might say something like, well, we think the Cat B stores are over rented, and therefore we would like to reduce the rents. And they are the sorts of things that landlords need to understand, because frankly, if it's a loss making store, and it's made clear that it's a loss-making store and the data is provided to back it up, then they might accept the rent reduction. But if it's a profitable store, which may or may not be over-rented, and the company just isn't being honest about the fact that it's a profitable store that they're paying, that they think that they're paying too much rent for, then the landlords, I think, want to understand what is truly going on. And they're difficult questions. They're difficult questions, but it is the right time to be asking those difficult questions.
Yeah, I just to sort of echo that point, I think one of the concerning things that we have seen is, the categories don't seem to be, in some cases, linked to the store's profitability. They are tending to be linked to things like ERVs. And that's really, if it's a genuine restructuring, it should be linked to how profitable the store is, taking into account the cost of the rent. It shouldn't be, well, we think the store is worth this, so we think we can get away with reducing the rent to Y. So that is definitely something that has cropped up time and time again, I think, and is a real concern.
Thank you. Matthew, I'm going to come back to you for a couple of questions linked together, and they segue, I think, into a third, which I can open up to everybody else. But the two I want to start with you on are, on the one hand, what is the correct checklist of CVA requirements from a tenant such that they do not go beyond what's necessary and don't become a shopping list for the tenant's business success over an extended period? And then a second question, and you'll see the link, isn't it the case that the BPF red lines are such that they can't all or even substantially be met if you want to have a CVA that works for the retailer? Wouldn't they be better set at a level that actually encourages real engagement and give and take? Do you want to address those two, and then I'll come to the third?
Well, I think they are linked. So my answer to the first question was going to be to plug the thing that the second question is then criticising. So the BPF has published a set of 10 red flags, which is meant to be, it's obviously not a comprehensive guide, but it's meant to be a list of the more common elements of a CVA that as a landlord you might find objectionable. Let's just be clear about CVAs. The last CVA that I read was 483 pages long. Most landlords are not going to read a 483-page CVA. So having this red flag list helps you to hone in on what might be the relevant issues. So, for example, one red flag might be an upward downward rent review at the end of the rent concession period. And the reason that that is a red flag is not just because landlords don't like it, because obviously landlords don't like anything in a CVA. I mean, you're not going to like the fact that your rent has been reduced. The point about the red flags is that they are destructive of value for the landlords, but do not appear, certainly without more explanation, do not appear to be necessary to rescue the business, and that is why it's a red flag. So the upward downward rent review at the end of 3 years is an example of that. Another example of that would be a tenant break right in addition to a rent reduction. So you've got a Cat B store which the company says is, loss making or marginal, and so to make it profitable they have a 50% rent reduction. Even if the landlord accepts that, why should there also be a tenant break right in addition to that? Because that seems to be having two things when only one thing is needed. And what the company quite often doesn't understand is that you can almost live with a rent reduction for 3 years as a landlord, but having a rolling tenant break right for the next 3 years destroys your value as a landlord, because you can't value the rent roll because there's no guaranteed income. So I would certainly direct people to those red flags which are on the BPF website. They are the things to look out for, we think. They are common features of CVAs. I'm not suggesting that if you see a CVA with any one of those red flags, then you should automatically vote against it. But I think if you're seeing a lot of them, then that is telling you something. But if you're seeing one or two of them, then maybe you can take a view, but it's up to you. And as for, are the red flags ever really achievable from a retailer's point of view? Well, the point is, yes, we think they are, because as I explained, they are not just things which landlords don't like. They are things which do not appear to be necessary to rescue the company's business. And that is why they're red flags.
Thank you. Okay, so we're coming towards the end of the session. This is going to be my last round to each of my panelists. And the question is really this. How do we go forward from here? Is it by trying to head off the need for CVAs, by landlords being more proactive in reaching out to tenants and recognising the way things have changed? Is it by improving the CVA process, and what would you do to do that? Or is it something else? Is there something new and different that we need to bring into the equation to help tackle some of these challenges that we've talked about? And in answering, I'm going to ask each of our panellists to bear in mind one of the other comments on the Q&A function, which is to highlight this was the States Gazette leader calling on landlords to, quote, stand together and take, quotes, hard action with the growing number of occupiers who are taking the, and I can't say the next word, with CVAs. Is this strategy and language helpful? I'm sure my panelists wouldn't use language like that, but how do we also take some of the heat out of this and find a constructive way forward? Ian, I'm going to come to you first.
I would just, my only reaction, well, not my only reaction, but one thing that I was picking up that Matthew said, which I'd never heard about, is that there is a moratorium when you do CVAs.
It's not automatic. It's not automatic, but you can basically appoint an insolvency practitioner, and provided you can meet certain tests, you file some documents at court, and you get the benefit of a moratorium.
So that's interesting. So I'd never heard of that before. So somebody who's going into a CVA, certainly never heard of that. And in fact, one of the things I was going to mention from my perspective as someone who's doing a CVA is that there is no moratorium. Of course, we've got the government moratorium at the moment, but normally there isn't. And I thought that was strange because I think in Chapter 11 in America, I think, you correct me if I'm wrong, there's a moratorium. So you just freeze everything for a period of time. But look, sorry, Melanie, but as you know, to wrap it up, it's really interesting hearing this conversation, you know, from the panelists. It's clearly a lot of very complex issues at play here. I obviously see everything as very simple and very black and white. It's not that black and white. It's not that simple. I can understand that. But, you know, if you just boil it all down, I just go back to probably what I said earlier on, that there is a paradigm shift. It's going to be very unpleasant for everybody. It's unpleasant for all these retailers that are going bust or doing CVAs. It's going to be very unpleasant for all the landlords. And with COVID, in fact, we're pretty much all in it together. And as somebody said, if the landlords, of course, are borrowing money from banks and they can't get their rents and then the values of the properties collapse, it's all going to go back to the banks. And then in the end, the government are going to have to bail out the banks. And that's bail out the banks who are going to...
Yeah.
What? Yeah, again.
Yeah.
I mean, you know, it's just going to go up, and it becomes a worldwide, you know, government, you know, crisis of 2008, 2009, and you just got to shove money out there, which is what the government are doing. Because I think, honestly, we can all argue about this and about that and the complexities. We're all in this together. In the end, it's going to get down to the banks, and then it's going to get down to the government. Okay, and that's who need to be looking at this.
Which is yet another webinar, I suspect. Brief final thoughts from my other panelists. Christina.
Yeah, I mean, I think just to kind of summarise, I guess, what we've said is I think we are all in agreement that CVAs themselves, or the principle of how they were supposed to be used, isn't necessarily a bad thing. And the bad thing, I guess, that's come out of them is what they've sort of morphed into, and the misuse that, you know, insolvency practitioners have potentially advised retailers to go down that route, whereby, you know, landlords are disproportionately affected by, you know, they don't really have any say in the process, and they're disproportionately affected by the outcome. So I think there has been quite a lot of discussion as, you know, to standing against the CVAs to try and sort of set a precedent for retailers going through this. Yes, as landlords, we do need to sort of lobby together and sort of try and lobby against this misuse. It's difficult, you know, if we are having this misuse, will us banding together and voting against these CVAs have an impact on whether they go through or not? I think what we really need is a change in the legislation and how it works, so that no one creditor, unsecured creditor, can be adversely affected. Like is happening at the moment, and we're just unfortunately not there yet. So I think a lot more transparency needs to happen. We need to be, you know, have oversight over store profitability, you know, actual turnaround plans as well. That's something, you know, I sat in on a CVA call not that long ago, and it was repeatedly asked. You know, it wasn't the first CVA that this company had gone through, and it was repeatedly asked by various creditors on the call, you know, what's different this time? Why is the business going to survive? What have you put in place? And there was not even an attempt to answer those questions. So I think, you know, a really proper, robust turnaround plan to show it's been thought about, and it's not just an exercise going through to cut rents. I think is really key, because I think there's a lot more than just cutting the costs. Obviously, that is a massive help in that situation, but there's a lot more that goes into the turnaround of a business than just cutting the costs. I think
Thank you. Matthew, I've overworked you, I think, already, and I'm conscious we're starting to lose our audience because we're running over. So if you'll forgive me, I'm going to skip over you and give the last words to Stuart, who I think got a name check just then in terms of his trade, at least, if not personally. So
outrageous.
I'm going to leave the last word to you.
Thank you. I've got 2 points. One is my sell of the CVA, but the first one is I think we need to appreciate, as Christina said, there are good CVAs. And there is a difference between a CVA being unfair and there being a perception of it being unfair. And I think what we need to do is give more information. If we can provide the information so that people know why decisions are being made, then it's easier for people to understand why the VA is being proposed as it is, and to get rid of a perception of unfairness if in fact there is no unfairness there. So I can understand that desire for greater transparency. The last thing I'd like to do is try and promote the use of CVAs, though. Commercial landlords are very astute people, and they have a lot of small tenants that are finding themselves in a very unusual situation where they have very little control over what's going on and are losing money and don't know what to do. And this is an opportunity for commercial landlords to take their tenant by the hand and say, let's work through how we can get you to somewhere where you can start making money again. And a VA is a good way of doing that. And a VA is a particularly good way of doing that at the moment. Because if a landlord is saying, I know you cannot pay the rent, I will write some off. Why doesn't the landlord suggest a CVA is used so that the tax man also writes some money off? Because the more money that other creditors write off as well, the more that company will be able to in the future pay in rent. And we have a deadline of the 1st of December. That's when the taxman's revenue becomes a preference in a voluntary arrangement and will have to be paid unless they agree otherwise. So if you as a landlord can say to your tenant, let's go into a voluntary arrangement now, I'm going to write off some rent. We can bind the taxman into writing off some of his tax. Get it done quickly. Start speaking to people now. You can get it done, and the landlord has the possibility of a rosier future and a tenant with more money to be able to pay them. That's my CVA sell.
Thank you, Stuart. And if anyone wants to know more about that last point in the reintroduction of Crown preference from the 1st of December, I think, get in touch with Rachel or Jon at the BPF, and they can fill you in more detail on that. So
you may even find that VAs are slightly cheaper if the R3 were to produce a simple pro forma for little tenants to use.
I was going to say,
What's this space?
I think some of the issues with the small retailers going through CVAs is that they tend to be very cost prohibitive to the smaller guys, and it tends to be the bigger guys that can afford to go through the process. So
I'm going to call a halt there. But all it remains for me to do is to thank all of my panellists. I found that a really fascinating discussion, and I think you've seen from the amount of energy, questions, comments that were coming through on the chat line that I think participants have enjoyed it too. So thank you very much indeed to my panellists. Thank you to everyone who joined us. And I hope you all enjoy the rest of your days. Thank you very much.
Thank you, Melanie. Thank you.
Yes. Thanks. Bye.
Bye-bye.
Bye-bye.